Hi everyone, I'm a little late in preparing this video for you, but I wanted to make you a video about legal writing as promised. We are now entering the final quarter or third of the semester, and we're going to be spending the remaining few weeks learning how to build the foundation of legal writing. So obviously we have a whole nother semester to work on this skill. So just like everything else, the pieces are going to start to come together. But I wanted to give you this overview, and we will continue to talk about it in class. So as I make this video, it is now November 15th, and we have this week, we have the week of Thanksgiving, and then we have 3 more weeks. So there'll be a lot of opportunity for us to work in class on the writing component and do some work at home and review our work together in class. So one thing I wanted to ask you guys in class tomorrow, but you can think about it now, is when we think of legal writing, what really comes to mind? I mean, clearly we are a profession of the legal word, but what comes to mind when we think of legal writing documents? What do we think about? So I just threw a handful of types of legal documents on the PowerPoint here, but of course there are many others. Some of you may have thought about legal writing documents like a contract or a deed or a mortgage. Certainly those of you taking wills, trusts, and estates, your mind might have immediately gone to a will or a trust as a legal document, and of course they are. Maybe some of you who are taking litigation or have some experience have been thinking about documents that get submitted in court as part of a lawsuit or litigation, advocacy type documents like motions, briefs, complaints, letters. We're going to touch on a number of these throughout next semester. But the one that we're going to focus on in this class, which is really the foundation of all legal writing, is something called the Interoffice Memo. And I think you're already aware of it because I asked you to read several chapters in your book devoted to the legal memorandum. Specifically, I'm just going to mention it here because I do think your book does a pretty good job of laying out how to draft a legal memo. The chapters in particular that you will want to focus on are 19, 20, 21, and 22. There's others in there that are helpful too, but those are the 4 big ones that are going to break down for us the Interoffice Memo. But I'll get back to that in a second. I wanted to start by thinking about those legal writing documents just in general, because there's a couple of principles that I will ask you to keep in mind as we move from the legal research portion of this class into the legal writing. And that is that we always keep in mind, who are we writing the document for? In other words, who is the intended audience of the letter or the particular piece of writing? And what is the purpose of my legal writing? Because these can differ document to document, assignment to assignment. So it's like you almost want to take a little sticky note and put it on your computer. So as you're typing and researching and working on a document, you remember, who am I writing this for and what is the purpose of this writing? So in legal writing, we have a number of different audiences. Sometimes we are writing documents where the court or a judge or judges are the audience of the document. We might be writing like a motion where we want to ask the court to do something. Sometimes our audience is the opposing party in the lawsuit. I said opposing counsel, but if we're representing the plaintiff, we may need to communicate with, send notification to opposing counsel, the opposing attorney, or the opposing party. Sometimes the audience is our own client, right? We write emails to our clients, we write letters to our clients. And sometimes the audience are third parties altogether. We may be requesting information from a government agency or communicating with a witness in a written document, sending a subpoena to that witness, for example. So these are people that are not parties to the case. They are third parties that just may have some information that we need, or they're related to the matter. And sometimes our audience is multiple of these. We might be writing to both opposing counsel and the court at the same time. So we always want to keep in mind who we're writing to. And something to start thinking about is how the tone of the writing may take a different shape depending on who the audience is. For example, we might already assume that we would take on a certain tone when we're writing to the court? What about when we're writing to our client? Or what about when we're writing to an adversary, opposing counsel? Could each have very different tones? Absolutely. Related to that is the purpose of the legal writing. So again, just as there are varied audiences in legal writing, there are varied purposes in our legal writing. Not every document is created the same. Some documents we draft to persuade. Those are those advocacy pieces like a complaint or a motion where we're trying to argue to the court to rule in our client's favor. Those are persuasive pieces of writing. If that suddenly reminded you of like being in middle school and into high school when you learned about informational writing and narrative and persuasive writing, we are back to the basics. So we are going to learn next semester how to write persuasively to the court when we're trying to advocate on behalf of our client. Sometimes we write information pieces, like we might be requesting information or we might be providing information. So informative writing is much more neutral in its tone. We're not trying to advocate that our client should prevail or the matter should be, decided this way in the court. It's really just informational. And so when we talk about the interoffice memo starting this week in class, we will be talking about an informational piece of writing, not persuasive yet. I also wrote confirmatory here because we often write letters and information because we want to confirm information with another party. Again, it's a more of a neutral, objective piece of writing. So just an overview. Again, I'm a big fan of the sticky note. Write down, this is the document I am writing. This is the audience or audiences that I am targeting. And this is the purpose of my document. Because that will really put you in the right frame of mind to address whatever the writing assignment is. So in this particular class, between now and the end of the semester, we are going to focus on one and only one type of legal writing. And that is the Interoffice Memorandum. The Interoffice Memorandum is such a foundation piece of legal writing that first-year law students tend to write several of them in their first semester of law school, because it's really the document that we build upon all other kinds of writing is the Interoffice Memorandum. And paralegals write them too, so hence introducing them in this class. The audience of the Interoffice Memorandum is internal. It is a document that is assigned to you, the paralegal, or to another attorney from usually a supervising or senior attorney. And so we write the Interoffice Memorandum to that assigning attorney. It is not a document that is shared outside the law firm. The Interoffice Memorandum is not even usually shared with the client. We can take the information from the memo and usually we would turn it into a letter that is written in a tone and in a manner that speaks to that particular client. So I want you to think of the Interoffice Memorandum as a purely legal document that is shared only among the attorneys in your office working on that particular legal matter, the attorneys and the paralegals, and that's it. Does not go to court, certainly does not go to opposing counsel. And again, sometimes the information can be turned into a client letter, but we don't usually share the memo itself with the client. Now, the purpose of the memo is to inform. So again, neutral, objective piece of writing. We're going to inform the client about their likelihood of success or not on their particular case or their legal matter. So this is the document that we produce when a scenario like this arises. Someone comes into your law office and, again, pure hypothetical, they've been terminated from their job. And just to bring it back to an example we used early this semester, assume they believe that it's due to pregnancy discrimination or discrimination on any basis. And they want to know, do they have a case against their employer? So it is incumbent upon us in potentially representing this plaintiff in a civil lawsuit against the defendant to answer, yes, I think you do have a case, and so we should file a complaint and we should move forward with with a lawsuit. Or maybe we think the client's facts are not so strong and we think that the client should not bring that case or not bring that particular lawsuit. And this scenario can also come up if you're representing a defendant who has been sued, because maybe your client calls you and says, I've been sued for employment discrimination or breach of contract or negligence. Insert legal theory there. And similarly, we would do research on behalf of our client, the defendant in a lawsuit, to inform the client about the likelihood of success or failure of their defense or of the plaintiff's claim. So in other words, this is a type of writing where we are going to be assessing for our client, do we think you have a case, and why or why not? So that is our task, is to do that work, that research piece, and we'll talk about it in a minute, and then produce a piece of writing. So here are the pieces of the puzzle that we're going to put together. First, we need two important pieces before we can produce the interoffice memo and an answer for our client. Do we think they will succeed or fail on a case or claim or defense? Number one, we need to know what happened to the client. We need to know the client's story. And again, this could be the plaintiff or the defendant. But what do we need to know? We need some factual detail about what happened to the client. If the client is claiming that they were fired for employment discrimination, I want you to think about what kind of details would we want to know just right off the bat about that client scenario. Or if we were defending an employer being sued, what would we want to know? Factually, like what kind of events would we want to know about? So that's piece number one, the client's facts. Piece number two, and this I should have highlighted on the page here, this is the research portion. We also need to know the applicable law. So in order to answer for our client, yes, you have a very strong case for pregnancy discrimination lawsuit, or defendant, you have a very strong defense in this lawsuit. We also need to know the law. And here is where all of the first 2/3 of the semester are going to come into play. Because how do we know what the applicable law is? Well, we need to research it. So we need to research potentially statutes, right? A code from a different state, a particular state or federal. We need to research case law that interprets that statute, if there is one, or just common law, if it's a common law claim. So we're going to come back to questions like, what is my jurisdiction? Where do I want to begin my research? And then we can bring those two pieces together and we can talk about whether we think the client will succeed or fail. So client's facts and applicable law will answer for us the success or not of our client. You might be thinking, this sounds a lot like precedent, and it does. So that applicable law piece, we're going to come back to talk about finding precedent and finding that mandatory authority that will help dictate for us what we think about our client's case. So the big tool to do this, I'll make a second video, but the couple of big pieces we're going to talk about is, of course, a strategy about how to tackle or attack or just really go about understanding our client's facts and researching the law. And then we'll talk about how to structure this particular piece of writing. And I use that word structure, I use it intentionally because there is an organized format for writing a legal memo. It's not stream of consciousness, and I promise I will walk you through so you'll know all the parts. I'll introduce that on the next video. See you there.